All right, so this judge in the Young Thug trial is really making lots of mistakes, in my opinion. He's now questioning the defense lawyer, Richard Steele, and Steele has come into possession of information. Now, he's going to say on information and belief. What lawyers do when they say that is they're saying, I don't know it to be true, but I believe it to be true. In California, and I'm a California lawyer, not a lawyer in Georgia, but in California, information and belief allegations can be valid if you cite the source of that information that warrants that belief. And that's the City of Los Angeles versus Doe decision, 2006. So the judge has had what's called an ex parte communication. Now, let me explain what that means. Ex parte is prohibited, and there are some small variations that would allow it to go through. Because it can cause mistrial and an unfairness in the system. Someone is not there that would normally need to. You can have an ex parte application, but in reality, they have to still give notice to the other side. Like, what happened here is apparently the judge, who seems to be admitting it, had a meeting with the prosecutors and a witness and a lawyer. And they never told the defense about this. And this is a witness that's been sworn in. Absolutely, the defense has a right to know about this. And the judge doesn't really want to hear what this guy knows about it. He wants to know who told him is the information. I think the judge has made a big mistake here, jailing the lawyer.
For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body.
Now that's a shot over the bow. What he's really saying is that I might just report you to the Judicial Commission or whatever agencies in charge of judges in Georgia. And, he's going to be charged with a criminal offense.
I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you?
Okay, so emailing this defense attorney that email is interesting because now there's no question there was a meeting.
Disturbed too, and the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia.
The lawyer's building a record right now to prove the judge wrong.
782 Southeast 2D 638 2016.
He's already researched
our highest
the case
court
law.
Says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of the record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to
No,
get
no, no,
anybody
no.
else
I'm
into
asking you,
any-
how did you get this
I'm
information?
not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have his. I have problems right now. and
Okay,
I'd like to
I know.
continue.
Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party.
Okay, I totally disagree with the way he just characterized that, the judge. A private ex parte communication, I've never heard of such a thing. But, you know, he's trying to also silence, I think, this lawyer.
I mean,
A
I would
party,
yes.
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court
Mr. Steele,
handed
ask
Mr.
me.
Copeland.
Tell me how you
perjury.
got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that, but I'm.
See, another mistake this judge is making is, for all we know, it's not as simple as the judge is saying. The judge is saying, give me the name. Who was it? Who leaked this information? And he's thinking maybe that's not privilege, it's just the name of a person. Confidential communications don't always exist between lawyers. And what this lawyer is afraid of is if he answers the question, that question as answered would give away something that is privileged. For example, let's say that there's a dead body somewhere and they say, just tell us the location. That's not privileged. Yeah, well, if the location is at his client's house, then the lawyer has to keep that secret to himself. No matter how repugnant it is, the lawyer has a duty of secrecy and confidentiality to his client. He can't waive that unless the client waives that. So sometimes the things are not as simple. And this lawyer is a very smart lawyer.
I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
No such thing as proprietary information. No way. That's not proprietary information. Proprietary information is information usually of commercial value. And this is not of commercial value. This is just some things that went on that this guy was not a part of.
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true,
look at the body language of this prosecutor right now. She's got her hands in the praying position. Interesting body language. She's slightly nodding her head and shaking her head to the side. And she's definitely reacting to all of this. And if what this lawyer is saying is true, it sounds to me like they're putting some kind of witness intimidation on this witness and basically saying, look, you know what? You don't have to testify. You could take the Fifth Amendment. But if you don't testify, we'll just hold you for another couple more years.
Is coercion, witness intimidation,
look at this.
ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there?
Right.
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question.
Okay, that's a good response by the lawyer. I don't want to be held in contempt. But, if the lawyer has to choose between the jail cell and violating his oath as a lawyer, you know what? Interestingly, he has to take the jail cell. Because that is his first priority, is his client, to zealously represent his client within the bounds of the law. And if it means this lawyer's got, giant balls. Okay, he's not selling out his client. He's going to take the hit and then hopefully reverse it. And quite frankly, I think he can get this reversed, because I don't think there was any basis to do this to this lawyer.
That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I tell you
what, I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt, because that is not attorney-client privilege.
Attorney work product privilege. I am not.
Okay, so the lawyer is now shifting from attorney-client privilege because maybe there weren't no real attorney-client communications, dispensation of legal advice. However, Now he's going to work product, which are the thoughts, the impressions, and strategies of the lawyer, which are also protected so that the other side doesn't just, do all the, get all their insights from being lazy and glomming onto the other attorney here. Maybe it is covered by work product, but he was smart to assert that too. Also, there's probably some other privileges that he could assert, for example, his Fifth Amendment, et cetera, because he is going to be charged with a crime. But the judge, I think, is way over the line here.
Now, how did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
Yes.
You got 5 minutes. Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that
Now he's cutting off his ability to say what he wants to say because the judge is not on the bench.
he admitted to.
But remember, there's a reporter here. So the reporter is forced to keep taking it down. You watch the lady in the green right here. She's taking it down anyway. Smart move by the lawyer. He may not get another chance.
Killing Donovan Thomas and don't take my notes. No.
All right, so there you go. There was another hearing, or another time the lawyer was now being taken into custody. You could tell he's not used to being taken into custody before because he didn't take his watch off. What you want to do is get rid of your watch, your ring, jewelry, wallet, all of that stuff, and not have anything of value on you so it doesn't get, locked up and stolen or whatever, get damaged, But I think the judge has unnecessarily aggravated this, and it didn't have to occur on television. This could have occurred privately in his chambers, and it could have been hashed out there. But now, he's just jailed a lawyer. I have to watch. Looks very, very, it looks just absolutely insane to me.